this is a crazy story. And so I wrote about this last night. You can access it over at Substack, chapter and verse, for you subscribers. So a judge, U.S. District Court Judge Sharon Coleman, she's out of the Northern District of Illinois, no surprise, was referencing lower court rulings. She dismissed a firearms possession charge against Roberto Flores, who was illegally in the United States and was caught with a handgun in Chicago on June 1st of 2020. Now, here we are almost 4 years later, and this is now up. Finally, there's movement on it. They said that, quote, this is what she wrote. She was appointed by Barack Obama. This is what she wrote. She had an 8-page ruling. Quote, the court finds that Flores' criminal record containing no improper use of a weapon, as well as the nonviolent circumstances of his arrest, do not support a finding that he poses a risk to public safety such that he cannot be trusted to use a weapon responsibly and should be deprived of his Second Amendment right to bear arms in self-defense. Now, as I noted in my piece, he doesn't have a Second Amendment right to self-defense. Now, I know that there are some like of the anarcho, or what is it, what do they call them, anarcho-capitalists, things like that out there, or capital L libertarians. I had a very nice conversation, though, with a couple of them yesterday. This, to me, is not an issue of it's not so much an issue of gun control. And I want the right to be very careful to not get baited in this, because I feel like they're trying to bait you, the left, into either defending open borders, so as to, in your mind, protect 2A, or to advocate for more gun control so as to oppose people in the country illegally possessing a firearm. Here's the problem with all of it. You don't have to do either of them. You don't have to do either of them. I've seen people get into nasty arguments with others, and people disingenuously arguing that denying someone a Second Amendment right based on whether or not they are in the U.S. legally others them, or is somehow racist, which is the stupidest thing. It's a bunch of deflective DEI word salad chum. And the whole point of it is to hook, to bait, to hook unsuspecting, unassuming Second Amendment supporters into defending this garbage. But like I said, this individual was in the country illegally. That alone, that's in the United States Criminal Code. It's 18 USC subsection 922 subsection G. And what this states is that prohibited persons are identified in this part of the criminal code. And this is for whether or not you agree with the Gun Control Act or not. And that's a whole other issue. And believe me, I could wax patriotic about opposition for a long time. But this law says that if you fall into these categories of persons, then you are not allowed to transport, receive, possess, or anything, firearms, ammunition, etc. If you're a fugitive, if you've been convicted of a crime that punishable by imprisonment of a term that exceeds 1 year, if you're a drug user, that's Hunter Biden. If you've been adjudicated mentally defective, that's the legal term, or been involuntarily committed to any kind of mental institution. If you are an illegal alien. In fact, when you fill out your 4473, that's one of the questions that you are asked if you are in the country legally and you're legally able to purchase, because that is a disqualifying factor. And so this has been law for quite some time. Now, to me, that's the issue. This individual was in the country illegally and is a prohibited person. I'll be damned if I got to get a tax stamp to get a silencer. You bet your 8 snakes we're going to go by the letter of the law on this. Now, this has nothing to do with othering. It has nothing to do with any other DEI word salad garbage. Although, I got to say, you got to give the left some credit. I wrote about this in my first book, Hands Off My Gun, because they've always been on the wrong side of history on this. They've always wanted to disarm minorities, to disarm women, even to the extent of arguing, as Chief Justice Taney shamefully did in Dred Scott v. Sanford, that the recognition of Black Americans would automatically affirm as citizens, would automatically affirm their Second Amendment rights, thus they can't be considered citizens as everybody else. Flores' case, though, is not a case where citizenship was denied. He didn't even ask for it. So that is a straw man argument to claim that this is somehow, and that's the crux of this, that there's discrimination involved, or that he was othered, or that there's any identity political box that has to be checked. He was denied. He wasn't denied anything. He did not apply. Now, here's where I differ from a lot of people on stuff. I believe, now let me finish my thought. I believe that the Constitution affirms the natural rights of U.S. citizens. The difference between natural and civil rights, you all know this? Natural rights you have by nature of being a citizen of this United States. Whether you become a citizen of the United States or you were born here, you have these rights. They are not civil rights, which are created in civil courts by humans and then given with conditions to other humans. The Constitution, the Bill of Rights, simply affirms and reasserts the sovereignty of those rights where it originates in the face of government. Now, here's where I differ from people. This is an issue of we the people. We were fashioned as a republic. And the people who comprise the republic, unlike monarchies and everything else, we are the sovereignty. Because government derives its authority from the power of our consent. We the people, this is evident not just in the terminology used in our founding documents, but in the ancillary debates that were underway by the founders at the time that these documents were crafted, further supported by the Federalist Papers. We the people, we being the republic, we are the sovereign. The people are the sovereignty. Those outside of the republic cannot lay claim to the protections of it. And sadly, as I mentioned at the start of the hour, in this very upside down world, American jurisprudence is under brutal attack. Our legal system doesn't even want to define what a woman is. So it's no surprise that they're trying to change the definition of our republic and we the people to further erode the people's sovereignty and our borders. That is what this case is about. That is what this issue is about. This Flores individual who willingly entered the country illegally didn't even ask for citizenship, but demands the protections via the affirmation in the face of government from it. He wasn't denied anything. He never sought it. So he wasn't othered, but you know who is being othered? And don't let them get this twisted. It's us. It's you. You're being othered. You're being tossed by the wayside. The respect for the authority of the people is what is being tossed by the wayside. And they're going to try to bait you into arguing that, well, I guess you don't believe really in natural rights. But see, our republic affords the protection to the citizenry, we the people. A fist in the face of the government asserting and demanding that they recognize the natural rights that we were endowed with by our Creator as citizens of this republic. That's not a discriminatory position. It's a position of empowerment. And it is not the people's fault that this illegal alien chose willingly to go and do everything else but apply for citizenship. Even so far as getting a lawyer and litigating this issue for years. He could have been probably a damn citizen by now. So this is an attack on American jurisprudence. Do not let them get it twisted and bait you into making it anything other than that.